Observers of the law have noted that it is probably one of, if not the most, restrictive gun law in the United States. And not surprisingly, the law is currently being challenged in court under the grounds that it is in violation of the Second Amendment to the U.S. Constitution. And while we're on the subject of the Constitution, I want to point out that the Sacred Heart University Press has published copies, I hold in my hand here, of the Declaration of Independence and the U.S. Constitution, which I encourage you to pick up. And we also have copies of the Connecticut State Constitution as well, which again are sitting over there on the table, and they are free of charge. I would recommend that you pick one up, and it's always good to carry a pocket copy of the Constitution with you. The Second Amendment of the Constitution says this: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so this law was passed up at the state capitol, and many people took issue with it. But let me just tell you about the law that we're going to be debating, and then I'll introduce our speakers. The major changes in firearm laws pertain to assault weapons, handguns, pistols and revolvers, long guns, which includes rifles and shotguns, and large capacity magazines. The bill, among other things, expands the ban on assault weapons, bans the sale or purchase of large capacity magazines that can hold more than 10 rounds of ammunition, mandates the establishment of a deadly weapon offender registry, bans the sale of armor-piercing bullets, adds 2 members to the Board of Firearms Permit Examiners, expands the circumstances in which mental health history disqualifies a person for gun permits or other gun credentials, requires anyone buying ammunition to have an ammunition certificate or other gun credential, and appropriates $1 million to the Department of Emergency Services and Public Protection for fiscal year 14 to fund the statewide firearms trafficking task force. That is a summary of the bill. Our speakers today are here to debate the constitutionality of that law. And let me introduce them to you. Sitting immediately to my left is State Representative Rob Sampson. Representative Sampson is currently serving his second term in the Connecticut State Legislature, and he's representing the 80th Representative District in Connecticut. He's a member of the Appropriations, Insurance, and Real Estate Committee, also the Environmental Committee. He was appointed to the Bipartisan Task Force for Gun Violence Prevention and Children's Safety. He is known at the state capitol as a supporter of gun rights, and he also is known as a pretty strong opponent of Governor Malloy. He's opposed the governor's budget, and he's also known as an advocate of limited government and certainly lower taxes. So we're very pleased that the state representative has joined us today. Sitting farther to my left is Mr. Ron Pinciero, who I should note is one of the key authors, perhaps the key author, of the law that we're debating today. So it's only appropriate that he's with us. Mr. Pinciero is no stranger to Sacred Heart. He has been on campus before. He is the Executive Director of Connecticut Against Gun Violence, which was formed in 1993. He is without a doubt known in Connecticut as the strongest advocate for gun control. And his work certainly at the Capitol has attracted state and national attention. And he is known clearly as one that has very little tolerance for extensive use of firearms. And so we're really pleased that he joins us today too to discuss this matter and to debate the bill, and to debate the law, I should say, with State Representative Sampson. Our format's going to be as follows. I'm going to let each speaker come to the podium here and present their position on the law. Each speaker will go for approximately 10 minutes. After that, I will feed some questions to the speakers. They'll remain at the podium. in order to stimulate some debate. With about 15 minutes remaining in the forum, we will then have some Q&A from the audience. So we hope that you enjoy this forum, and I think that we're in for a very lively discussion here. And once again, thank you to both of you for joining us today, and I think this is going to be very exciting. So on that note, I would ask Mr. Sampson to come to the podium, please. And Mr. Sampson, you voted against the law, and could you tell us why?
Good afternoon, and happy Constitution Day. Thank you all for coming to this event as well. I think it's important to take part in a good discussion on important events, for sure. Thank you to Mary Rose and to Sacred Heart University for putting on this event. It's an honor to be here and to be asked to take part in this discussion, and also to speak on behalf of our nation's history and the principles that define us as Americans. The law that passed this April was in direct response to the tragic events that occurred at Sandy Hook Elementary School last December. And I want to start by saying that I know of no one who was not horrified by that tragedy and certainly sympathetic to the families of those involved. And I also don't know of anyone that wouldn't favor policies that might prevent another similar incident. The debate is really about what those policies should be. Ultimately, what passed is what I would describe as a huge omnibus type bill, which is a whole other issue that I think is worthy of debate, but we don't have the time for that today, so we'll skip forward. The bill contains some actual good policy items, stricter mental health lookbacks, expanded requirements for the safe storage of firearms, and some strengthening of some existing laws. If the bill contained just those items, I would have supported it, because I believe that would have been a positive step forward to reduce violence everywhere, both with and without guns, and certainly in our inner cities where these types of tragedies are unfortunately commonplace. Our debate today, I think, is going to largely be about the other items that were part of that bill that I opposed and that Mr. Pintiero has been advocating for all along. Things that I would describe as a constantly shifting and arbitrary ban on the cosmetic features of certain types of firearms, having nothing to do with their function or lethality. We're talking about what's called semi-automatic firearms, guns that fire one round per pull of the trigger, not machine guns as are often referred to. Machine guns have been heavily regulated in the U.S. Since the 30s. Also, arbitrary limits on the capacity of ammunition magazines that go into particular firearms. And finally, increased fees, licenses, registration requirements that are only going to have an impact on law-abiding citizens in our state, and who by their very nature have no criminal history. I said during my speech on the floor of the House of Representatives when we debated this bill that what we need is criminal control and not gun control. There are indeed things we should be doing. We should be restoring the death penalty in Connecticut. We should be enforcing our existing laws. We have many, many existing very good gun laws. And we should be actually prosecuting offenders. You'd be surprised how few people are actually prosecuted for the laws that are on the books currently. And in contrary to the governor's policies, I think that we should be keeping criminals in prison instead of releasing them before their sentences are fully earned. And they're often released without any supervision. When a horrible tragedy occurs, people have a natural desire to try and do something to prevent it from happening again. And in the case of the tragedy that occurred at Sandy Hook, it seems like a simple fix. If you eliminate the implement of destruction, then of course this sort of thing can't happen again. However, I think if you take a step back and you think about that rationally with common sense, you realize that merely passing a law is not going to achieve that effect. A law is not going to eliminate the intent of a madman or his desire to commit such an act. Even more obvious is that such criminals have no use for laws. A maniac who is prepared to commit mass murder is not going to be deterred by some law about how many bullets he's supposed to have or what his gun is supposed to look like. Consider for a minute the crimes that were committed at Sandy Hook. He stole firearms. He possessed a handgun under the age of 21. He shot and killed his own mother. He then transported the stolen firearms. He brought those firearms onto school property. He then forcibly broke into a school and proceeded to murder 26 innocent people. And finally, he took his life, his own life. Those were just some of the laws that were ignored by the killer at Sandy Hook. Do we really think that adding any more laws might have stopped them? Mr. Pinciero will claim that these new gun control measures make the world a safer place. Yet, I turn on the evening news every night, like a lot of other people in this room probably do, and you will see that there are still murders occurring in New Haven and Bridgeport and Hartford at the same rate they always have. And in fact, the most strict gun controls we have in the entire country happen to be in Chicago and Washington, D.C. And coincidentally, that's where we have the most gun violence. Proof once again that more gun control laws, that they're simply ineffective. Ask yourself this: is a criminal who is sitting in his car moments before he's about to go into a convenience store and rob the place, while he's loading his gun, is he going to stop when he gets to 10 rounds? Of course he's not. The truth is that laws are only going to affect people who will obey them, and they have little impact on criminals, in effect disarming those of us who might prevent crime and in fact making us all less safe. When someone breaks into your home in the middle of the night intent on doing you harm, there is no law that is going to protect you. Consider the Cheshire home invasion from a few years ago. What is your protection from this horrible kind of thing happening to you? Of course, the police will come, but they'll show up after it's all over. The notion that more laws can prevent crime relies on the theory that these laws would act as a deterrent. But what I think is really funny is that the same advocates that are for more and more gun control measures are typically the same folks that are against the death penalty. So I ask, if the penalty of death is not a significant enough deterrent to stop someone from committing such an act, then how is some law that restricts an adjustable plastic stock for a rifle, for instance? So there you have it. I think it's clear that gun control laws are simply ineffective. But I want to talk about something even more important to our discussion today, and that is an understanding of our history and how the Second Amendment, I think, is key to what makes us Americans. Of course, there are many things that led up to our declaring our independence and the birth of our great country. But it's worth noting that the actual start of the Revolutionary War occurred when the British attempted to confiscate the arms of American colonists at Concord, Massachusetts. Remember the shot heard around the world from grade school? Well, that was our forefathers defending their freedoms and protecting their arms from being taken from them by using arms against their own government. That war was won, and we have the freedoms that we cherish today because they were armed. And they were also armed similarly to the British soldiers, which is a worthy point when we start talking about some of the Supreme Court language. Somehow, gun control advocates have been somewhat successful in painting anyone that would make that case as if they're loony. But it's far from it. All you have to do is turn on the evening news, look at Syria. In the 20th century alone, maybe 50 million people have been murdered at the hands of their own government, often after they were disarmed by that same government. After our revolution, our founding fathers drafted the U.S. Constitution and the Bill of Rights, keeping their own recent history clearly in mind. The Second Amendment is key to defining what makes us Americans. We went from being subjects to the King of England before the Revolutionary War to essentially becoming kings ourselves afterwards. What I'm talking about is what our founding fathers believed in, which was natural rights, that we have those rights inherently. And then if we were going to have a government, the government should be restricted from affecting or impacting those rights. I'm talking about something, individual sovereignty would be another way to describe it. As Americans, we make our own decisions. And that includes how we protect ourselves and our property. And it also includes what government we will have. And also what laws we find acceptable. Our American form of government was founded on these principles. And it's clear if you read our history and you read Madison or Jefferson or any of the other founding fathers that were involved in the drafting of our Bill of Rights, you'll see that they felt that the Second Amendment, so important that it was second only to our First Amendment freedoms, that it was key to protecting our entire set of natural rights that we were born with. Despite what laws are passed, including the gun control law that Professor Rose spoke about, and the belief of many of our elected officials, including my colleagues in Hartford, that what gun laws we have are up to them, it's not true. At least not lawfully. Our Constitution and Bill of Rights were drafted to restrict the government from interfering with our natural rights as citizens and to guarantee and preserve our individual freedoms. Simply put, the government does not have the authority to interfere with these natural rights, a fact reinforced by history and enumerated in many Supreme Court decisions. I believe that the gun control bill that passed this past year is certainly unconstitutional on those grounds and many more. And further, I think it is bad policy because clearly those laws are ineffective and they are in direct contradiction with American history and values. Thank you.
Thank you, Professor Rose, and thank you for your comments, most of which you can guess I would disagree with, but we'll save that for the debate portion. And I'm very happy to have been invited here today. I do have a history with Sacred Heart University. My uncle, Anthony Pinciero, was at one time president of Sacred Heart University, so I've seen the university come a long way and become a tremendous university over the years, so I'm very happy to be here. I'd like to start with a brief history of the Second Amendment to bring us to where we are today. As Professor Rose said, the Second Amendment is really a very, very simple clause, 27 words. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's the entire text of the Second Amendment. But what exactly was the intention of that amendment? Was it a collective right for the purposes of establishing a militia form of security? Or was it an individual right for self-defense or other purposes? That question has plagued us for more than 2 centuries. Since the signing of our Constitution, there have been only 5 major Supreme Court cases that have addressed the issue. The first 2, Cruikshank versus the United States in 1874 and Presser versus Illinois in 1886, determined that the right, and I quote, is not a right granted by the Constitution. The Second Amendment declares that it shall not be infringed, but as has been seen, means no more than it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government. There was great concern at the time of the signing of the Constitution that the states were going to lose their power and were going to be taken over by the government. And specifically, they didn't want a standing army. They wanted state militias to protect them. They didn't want the government taking that away. So Cruikshank determined only that it should not be infringed by Congress. That was the first Supreme Court case. The second, Presser versus Illinois, basically reinforced the same argument. The next case, in 1939 now, this was at the time when, after Prohibition, it was the days of the mafia and machine guns and Tommy guns and Al Capone, and that case was brought before the Supreme Court. And here they specifically addressed the individual right versus the collective right, individual versus association with a militia. And that ruling said, quote, in the absence of any evidence to show that the possession or use of a shotgun in the case that was being deliberated, at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. So beginning in 1940, settled law in the United States was that this was a collective right associated with a militia, but it was not settled that it was an individual right. That interpretation stood until the beginning of this century, the first decade of this century, with DC versus Heller in 2007 and McDonald versus Chicago in 2010. In the Heller case, the 2007 case, DC versus Heller, Justice Scalia wrote the opinion. It was a 5-4 decision. And he said, and I quote, "The Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes, such as self-defense within the home." Clearly established the individual right now. Changed from precedent, but clearly established the right, and that's what the Second Amendment says, and that's what we honor. So the DC handgun ban, which was the issue, was declared unconstitutional. But Scalia also said in the ruling that, like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. So the ruling left room for restrictions on the keeping and bearing of arms based on public safety considerations. Now, where the ruling was most unclear, and a big part of the issue why we're here today, was in Scalia's following statement that the sorts of weapons protected are those in common use at the time. No clear definition of common use was given then or exists now. The next case, McDonald versus Chicago, really asserted the same thing. You see, the first case was DC. The DC handgun ban was ruled unconstitutional. But as we know, DC is not a state. DC is a federal enclave. So they needed another case to bring it in, going back to the Cruikshank case, which said that it shall not be infringed by Congress, but that states and municipalities could make their own decisions. So they wanted to bring the 14th Amendment, the incorporation into the states in, and that's why they had to go ahead with the, with the following case, McDonald versus Chicago, and the same thing again in the states also. The right to bear arms was an individual right. So now we have the current Second Amendment interpretation that it is an individual right, that it is not unlimited, and one standard of judgment for constitutionality is common use. Now let's look at the laws passed in Connecticut and see how the new law stands up to the constitutional standards. First of all, know that there have been many Supreme Court challenges to existing state gun laws since the Heller and McDonald decisions. In fact, there's been almost 300 of them, and about every one of them has been unsuccessful. Here in Connecticut, after the Sandy Hook rampage, we passed an extremely comprehensive package of gun safety reforms, highlighted by improved revisions to our assault weapons ban and the sale of large capacity ammunition magazines. Included many other reforms as well, but those were the main things. Mass shootings like the Sandy Hook rampage and many others that we all remember, including the Aurora Theater, Batman opening, the Gabby Gifford shooting in Tucson, Virginia Tech, Columbine, oh yeah, just yesterday in Washington, D.C. It goes on and on. They're characterized by the use of semi-automatic weapons and the large capacity magazines that feed them. These weapons, with their increasing firepower and lethality, were intended for military and police use and were not intended for civilian use. The legislation passed in the last session and was signed into law by Governor Malloy on April 4th. And now the gun lobby has started to file the lawsuits. The first case, and this was brought in the state courts, is called Disabled Americans for Firearms Rights versus Malloy. In essence, the case claims that the ban discriminates against many disabled people who need these light, easy-to-handle weapons to defend themselves because of their disability. The second case, Chu versus Malloy, has been brought in federal court by the Connecticut Citizens Defense League and other gun rights groups, and claims that the bans are unconstitutional because they ban a class of weapons that are in common use, as we addressed before. They say that the language of the laws are unconstitutionally vague, and they violate the constitutional doctrine of equal protection because law enforcement and military personnel are allowed to keep these weapons while civilians are not. The third case, also in federal court, was brought by the National Shooting Sports Foundation, and the claim here is very specific. The law that was signed by the governor on April 4th moved through the legislature according to a special process called emergency certification. This process speeds up the path of a bill that the leaders of the legislators consider to be worthy of emergency action, in this case because of Newtown. The complaint is that the leaders, when they presented this signed emergency certification document, did not specify the nature and reason for the emergency. So let's look at the constitutional arguments. First is the common use argument. The plaintiffs complain that the types of assault weapons banned are in common use and are therefore protected by the Second Amendment according to Justice Scalia's opinion. But Scalia also said that this is a far more limited right, and that as long as citizens of the state have available to them some weapons that are sufficient for the purpose of defending themselves, the state may prescribe the possession of other weapons. In this case, so-called assault weapons, in the interest of public safety. With respect to the equal protection doctrine, I should simply say that this does not apply because the Act treats all persons exactly the same. It either discriminates against any class and has no discriminatory animus against disabled people. Law enforcement people are treated differently because their very nature is to defend the public at large, not just themselves or their homes, against all potential dangers. As far as the unconstitutionally vague argument is concerned, we believe this argument fails because vagueness challenges are usually permitted only when a law impacts free speech or a fundamental right, neither of which can be implicated here. And even if the complaint were not barred on this basis, it still fails because the core meaning of the ban is obvious and clearly not vague in all its applications. Finally, the NSF challenge to employing the emergency certification measure for deliberations relating to the bill is first of all curious that they brought this complaint in federal rather than state court, since the process is one that is unique to our state and really not a federal matter. But the complaint is at best a reference to a clerical oversight that was not at all material to the legislative actions. The case is stalled in early stages and competing arguments are yet to be filed. All these cases are currently making their way through the court process. It will be some time before they are finally decided, especially since there will be further appeals once decisions are handed down by the courts where they are being currently deliberated. Both sides will present their best arguments, and ultimately the courts will decide. We are confident that the new law will survive intact in all of its reforms. President Abraham Lincoln said once that there can be no individual rights against the best interests of society. So I ask you, what is more important to society? To have a gun in every nightstand, every glove compartment, every purse, as the NRA would wish? Or to limit the proliferation and increasingly lethal firepower of guns that create the easy possibility of rampages that leave 21st graders dead and many others forever traumatized in a matter of a very few minutes? Thank you.
Okay, so we'll turn now more to the debate portion of the forum, and I'd like both of our speakers to go back to their respective podium. And I do have some questions, but nevertheless, I know that Representative Sampson would like to begin by rebutting what he just heard.
I'll just briefly thank Ron for the first half of his remarks, because I think he did a fairly decent job of illustrating what is constitutional law in the United States, and that ultimately it falls with the DC versus Heller case and the McDonald case, which says that it is an individual right, not connected with a militia, that you can own a firearm. And I don't believe that's ever been disputed, despite what he says. I think that you, throughout history, can read Supreme Court and various expert testimony that says that it has always been construed as an individual right. And it's because of the belief that we talked about earlier, natural rights that we possess because of our birth, and our willingness of our founders to prevent those rights from being taken away from us by any government, including the one they were about to create. What I really want to talk about that I had an issue with was first where our rights come from, which I think I just addressed. But also, you said that mass murders like what happened in Aurora and Sandy Hook were characterized by semi-automatic firearms and lethality and so forth. And I would disagree. I think those instances are characterized by criminals, by mental illness, and potentially by psychotropic drugs. And I think that Ron should help me about this. In his own testimony against in favor of the gun control legislation when it was pending, he pointed out, and I agree with him, that most gun crimes are committed by persons who are prohibited from owning guns. So if that's the case, then more laws certainly is not going to make an impact on those people. And the question I have is, how can more laws that affect only the cosmetic appearance of a firearm, you keep referring to the lethality, but the fact is that you are targeting guns because they have an adjustable stock. The same gun without an adjustable stock and with is the same amount of lethality. There's no difference. So why is one to be banned and not the other?
I'm not sure how many points there were there, but I'll try to address them. As far as the lethality of semi-automatic weapons, if I'm correct, the shooter in Newtown fired, I think it was 145, 150 rounds in a matter of minutes. Some of those kids, one of those kids at least, was shot 11 times. A 6-year-old kid was shot 11 times. This was done in minutes. Semi-automatic weapons can fire 30 rounds in 5 seconds. There are videos you can see on YouTube that show that. As far as whether gun laws work, let me just say that Connecticut is considered, and this was before this comprehensive bill, was considered to have the 4th strongest gun laws in the nation, and we have the 5th lowest rate of gun deaths in the nation. So I believe that laws do work. And of course, the mass shooting situation, the type of situation, is very different from the everyday type of gun crime that we see. 75% of the gun homicides in Connecticut, 75%, are committed in the 3 largest cities of Bridgeport, Hartford, and New Haven. And those are mostly done with handguns. So there is no question that most gun homicides are committed with handguns, and are not, but this type of thing, mass shootings, is a different situation. Mass shootings tend to use semi-automatic weapons with large capacity magazines that feed them. The shooter in Newtown, 6 kids escaped, and a teacher, when he had to reload. In fact, he dropped one of the magazines as he was trying to put the other one in. 6 lives were saved when he had to change that magazine. The shooter at the Gabby Giffords incident in Tucson, Arizona, was captured by some of the people in the crowd when he had to stop and try to put in another magazine. So there is a difference there. And these shootings are horrific. There's not as many mass shootings, agreed, as there are everyday urban gun homicides. But the fact of the matter is, we have 300 million guns in the United States now. Of course they're going to get into the hands of the wrong people. We've got to stop this madness. When are we going to stop? When it gets to 600 million, to 1 billion? You think they're going to start, all of a sudden, stop selling guns? How many can we afford to have? We already have the largest amount of guns per population in the world. The second country behind us is Yemen, and they only have 58% of the guns per capita that we do. So where do we start? I think we start with the most lethal, most powerful weapons that were intended for military and police use and never intended for civilian use in the first place. To me, that's logical.
Simply no.
Mike went out. There we go.
Yeah, maybe it's not. It works when you tap.
He'll fix it.
Do I can hear us?
Yeah, why don't you? Why don't you do it now?
All right, as far as the firearms, I'd say that's just simply not true. As I illustrated and you can read the law for yourself. It has to do with just cosmetic features, whether they're made out of black plastic, whether you can adjust the stock, whether or not it has a specific type of grip. Nothing about the rate of fire, nothing about the size of the bullet, none of that. And to me, that's an even pointless argument because, again, the Sandy Hook killer was not supposed to have that weapon to begin with. So clearly the law wasn't going to make any difference. Any new law wouldn't make any difference. Ron pointed out that we had the 4th best gun control laws in the country at the time. Well, it still happened. And my point is, you know, forgive me, and you know, I really even hate to bring up what happened yesterday. My heart goes out to those people and the families and the victims' families and everything else. But I'm already hearing that this is spurring another conversation about gun control. To me, it shows the failure of gun control. It happened in Washington, D.C., where we have the greatest gun control laws in the entire country. I mean, I think that you know, Ron himself would say that it was a mecca for gun control laws, that that's what he would have hoped to have in Connecticut. And clearly it didn't make any difference. It happened in a facility where the people who work there are restricted from owning firearms. One of the things that struck me about the news yesterday was watching these people talk about how they had to cower under desks and in closets and that sort of thing. And it's because they were disarmed, essentially. They were unable to defend themselves. And of course, you know, one thing I want to talk about is that Ron is in favor of gun control. And I have with me his list of 7 proposals that ultimately ended up being the gun control laws that we have in Connecticut, more or less. The fact is that they only go after certain types of weapons and law-abiding citizens. There's nothing in here about mental illness. There's nothing in here about investigating psychotropic drugs. None of that. There's nothing in here about more enforcement. Nothing. It's just inconvenienced people that are law-abiding citizens who, yes, 300 million guns in the country, and they stop crimes every day. You never hear gun control advocates talk about all of the crimes that are stopped by law-abiding citizens who have firearms. That's an important fact that needs not to be overlooked. The mere fact that I own a firearm and I live in a rural part of the state is a reason why maybe my house doesn't get broken into. I mean, the fact is that as long as criminals expect resistance, they're less likely to go after and commit a crime. It's, you know, gun-free zones, something we should look at.
Thank you very much. Well, I have a question for, I think everybody can hear me. I have a question for both speakers. But we have to come back to original intent here. I am curious what the individual who penned the Bill of Rights would say about assault rifles. And specifically, I'd like both of my speakers to address concisely, at least, what their view is regarding what James Madison might say about individuals in this country owning an AK-47, and whether or not Madison would think that is consistent with the Second Amendment. So, would you like to respond to that?
Yeah, that's something that I thought a lot about, and I think the founders would be appalled to see what the situation has come to, what the confusion over the meaning of the Second Amendment has wrought. I don't think they could have ever envisioned this. I don't think that they could ever envision the fact that civilians would be walking around with firearms that could fire 30 rounds in less than 5 seconds, that people would be walking into definition. military features as they are for the civilian. It's become so. Anyway, but getting back to the real question, my personal opinion is that the founders would be appalled to see the kinds of things that are happening in the United States. Mass shootings are defined by incidences where more than 3 persons are killed at one location at one time. We have, in the United States, since 1986, we have more than 3 times the amount of people killed in mass shootings than the entire rest of the world combined. This is a problem. It's a problem we've got to face. This is not, we heard a trauma physician say yesterday after the Washington shooting, this is not America.
We're back in business. Yeah, Madison absolutely would have said an AK-47 should be a protected firearm, specifically. And the reason why is quite simple. I mean, the fact is that you have to go back and remember why our Bill of Rights says what it does. The Second Amendment is there because of the recent history that the founders of our great nation had just experienced. They were oppressed by a British king, and they declared their independence, and they had to fight back. And one of the reasons why they were successful is because they were armed similarly to the British government. The British redcoats, they had muskets. Well, then the American colonists had muskets. The fact is that we have been slowly but surely over time restricting the firepower of the citizens of this country. But I don't know that that necessarily is a good thing. I think that there is a potential there that our freedoms are being reduced in the process. Now, I'm not advocating that people should get up and go out and buy an AR-15. We are given rights, and the rights boil down to choice. It's an individual choice what you do. It's right for some people and not for others, but we should have absolutely the right to defend ourselves and our property in the way that we choose fit. That's what the founders believed. That's what Madison believed.
Let me just quickly respond. The Second Amendment did not say having been oppressed by the British government. Second Amendment said that a well-regulated militia being necessary to the security of a free state, the right to bear arms, etc. We're talking about the British government. That was a background, but that was not in the Second Amendment. Also, public safety considerations, as Lincoln said, are more important sometimes even than a right. I think a parent has the right to know that when they put that child on the bus in the morning to go to school, that child's going to come home.
Okay. My next question goes even deeper than just the Second Amendment, and I want to go back to the Declaration of Independence, actually. And I was concerned about what Madison might say about the Second Amendment, but Jefferson, in the Declaration of Independence, also wrote about a right to revolt. I don't need to read the passage, but of course we know that the right to revolution is rooted as well in the American political creed. And so I'm wondering how or does this right to revolt have any relevance today? And if so, how could that happen in the absence of sophisticated weaponry? Either one. Okay.
First, well, I think it's an extension, Gary, of Madison's thoughts on the subject what we were just talking about. And incidentally, the reason why the common use phrase is in there is because they were trying to get at what weapons were commonly owned by the public, that you shouldn't be restricting the most common types of firearms. And the type of firearms that are being restricted in Connecticut's gun laws are in extreme common use. Almost every handgun has a magazine of greater than 10 rounds now, so we're restricting guns that are in common use there. And the AR-15, which is nothing more People see this rifle and they are alarmed because they see it in military type scenes and movies, but it's just a modern rifle. I mean, back in the day, cars had chrome bumpers, now they have plastic bumpers. Today, firearms are made largely of plastic instead of wood because it's lighter. And they concentrate on the appearance of the weapon more than anything. Our founders believed that the people were supreme and that we had freedoms, and that our government, when we were going to establish a new government draft or a new constitution, a new Bill of Rights, the whole supreme thought should be that we are going to absolutely make sure that the government is responsible to the people. So let's keep the people armed. Let's keep the people with the freedom to express themselves and assemble and do what they need to make sure that that government is always accountable to them. That's why they didn't want to restrict their rights to vote or to own firearms, and to own firearms that were similar to what the military might have. And incidentally, even if we use Ron's logic that it's about a militia, what are we going to do, arm the militia with pea shooters?
Again, we come back to the question, how does your law, which was passed, signed into law by the governor, impact Jefferson's conception of a right to revolution?
Well, I think there's no question that the right to bear arms is an individual right. I don't contend with that at all, first of all. But as far as the argument that this type, just to go back one step, the original idea was we don't want a standing army. We want the militia to protect us. We don't want to give that much power to the federal government. Okay? That concept has long passed. The federal government has the power now. The states have had their right to determine what restrictions they want to put on these things, you know, in large part taken away by the Heller and McDonald cases. So the fact is, we are not protected by militia anymore. We have a National Guard, but it's not nearly as powerful as the federal army is concerned. The federal government certainly, if you want to look back at what Madison and Jefferson felt that as far as their concern about the fact that if we had a standing army, we'd be at war all the time ultimately. That's kind of true. So the concern now, I don't think, is nearly as much about the federal government taking arms against its citizens. If the federal government wanted to take arms away from people, they could do it. They wouldn't need assault weapons to do it. They have far greater powers to do that. So I don't really buy that part of the argument so much anymore. It's a totally different situation from what the founders had in mind in terms of how we should defend ourselves and our country.
Thank you very much. We have less than 10 minutes actually remaining in today's forum, and I promised you that we would have some Q&A from the audience. So would somebody like to rise and ask a question, sir? And you could direct your question to either speaker.
I'd like to direct it to Ron. First thing, you said something earlier, you mentioned Virginia Tech and high capacity, high power weapons. I believe if you check the history, you'll see that this is more of a statement. The shooter on Virginia Tech uses a .22 rifle. So if you'd like to check that, if you want to use that in the future, you should get your facts down. And also semi-auto fire, 5 seconds, 30 rounds. I wish I could do it, and I shoot all the time. Not possible.
There's a YouTube video that shows it.
But you're never going to pull that trigger 30 times in 5 seconds. You can't do it.
There's a YouTube video that shows you can fire 30 rounds with a semi-automatic weapon in 5 seconds, and with an automatic weapon, it's 2 seconds. It's there, just go and see it.
Question right here. Barry?
Just very briefly, just a couple of things I noticed about your argument very quickly is the preeminence of the Second Amendment, second only to the First. When they were submitted to the states for ratification, the First Amendment now was the third, and the Second Amendment now was the fourth. The first one was never ratified. The second original one was ratified in 1992. you seem to accept the concept that weapons should be limited. The weapons, the machine guns and sawed-off shotguns that were limited following prohibition and racketeering, but not limited this much. So one question would be, where do you draw the line? And the other problem I have from a liberty point of view is there seems to be a conflation that anybody that suffers from a mental illness is at risk of being a shooter. And one question I would have is, if this right is so important for personal defense, shouldn't it take more than just a diagnosis of a mental disorder to be precluded from having a firearm? Don't you also need a showing that that person is likely to cause some sort of mischief?
Yeah, I couldn't agree more. I think that we should consider all freedoms equally. That's why I have a great issue with many people that like to go after violent video games also. I mean, we have a First Amendment freedom as well. As far as the restriction of certain types of, let me address the first thing you said, which is the Second Amendment being the fourth. I'm aware of that. Maybe I'm using a little literary device in my comments, but nonetheless, the Second Amendment is second today, and it was considered something very valuable and important to the founders. That's the only point I was trying to make. As far as whether or not we should restrict certain types of firearms, you'd be surprised at things that are not restricted. I mean, you can own a machine gun, an actual full auto machine gun, and there are many of them owned by Connecticut residents and used at gun ranges regularly. And you know what's funny about that is that they are virtually never. In fact, I challenged my opponent to cite an example where one of them was used in a crime of any type. The fact is that this is a debate that should be about criminals and how to stop them from committing heinous acts, not about particular styles and types of firearms, because law-abiding citizens are not going to, speaking of your comment, really quickly, the one thing I would say is that we often, your concern about people that are diagnosed with mental illness being singled out. Well, people that are owning guns are singled out too. My opponent implies on a regular basis that anyone who owns a firearm is one step away from being a mass murderer. And it couldn't be any farther from the truth. The fact is that we live relatively safe lives in this country because of armed people, because there is less crime, because criminals are afraid to break into homes because for fear of being shot. And there are countless crimes stopped on a daily basis because of law-abiding citizens who are armed.
Thank you very much. This guy's hand right there.
As I understand, both of your arguments are based on the experience of this country. Mr. Sampson, that the drafters of the Constitution wrote the Second Amendment based on the War of Independence with Britain, and Mr. Pinsaro, I think over your arguments based on the experience of our country and evolution of weaponry over the last 200 years to what we have today. So my question to you is both this, for Mr. Sampson, if we dissolved our relationship with Britain more civilly than with a war, would there be a reason for the Second Amendment? And for Mr. Pinsaro, if the founders at that time could perceive that we might have modern weapons, if you had lived at that time, would you have written the Second Amendment differently, if at all?
We have about 3 minutes.
I can be very quick.
Good. So,
I'll be very quick, and I'll say that the Second Amendment was not the first of its kind. The English Bill of Rights predated it. There was a Virginia Declaration of Rights that predated it as well. And I believe the founders believed that we all had natural rights to be able to speak our mind, thus the First Amendment, and to provide for our own protection and the choices that we make, thus the Second Amendment.
I think, being what I am now and assuming I would have been the same then, and if I had to write the Second Amendment, I think I would have said, we don't want a standing army, we want a state militia. We can't afford to arm all of our civilians. So we want the ability for these citizens to have guns, and we don't want the federal government to take those guns away from them as part of the process to implement a standing army.
thank you. Actually, I think we have time for one more. Right there in the red shirt.
Earlier, you mentioned that a father taking his kids to school. And I'm a father. I actually have 2 daughters. And unfortunately, their school is not in the best place. There's around here when we ran out of power, but in 1 week the power was out, everybody went a frantic rampage. And how are you gonna tell me I'm more safe when you just limited me?
Let's not forget one thing. It's not me. This law was passed by the state of Connecticut. No, let me finish. This law was passed by the state of Connecticut, by the legislature. I don't have any extreme power. Yeah, it's what I wanted, but I don't have any extreme power over the legislature. All the polls show that this is what the people of Connecticut wanted. And the bottom line is that household gun ownership in Connecticut is 16.2%. 84% of the households in Connecticut do not even own guns. I don't own a gun. I live in Bridgeport. I'm fine.
Okay.
Yes.
It's actually past 3 o'clock now, but I noticed everybody's still here, which is great. And so I'm willing to entertain maybe 2 more questions. And how about Mr. Kane right there? I'll get you. 2 more.
Hi, Jeff Slack. For Ms. Pinciero, how do you explain the statistics, the Bureau of Justice Statistics and the FBI Uniform Crime Reports both say that gun crime has dropped 39% since 1993. At the same time, there were concealed carry permits and so on, and gun possession laws snuck between 1993 and now, and yet gun crime is down.
Gun crime is down for lots of cultural reasons. But if you compare the present with the present, and you look at the states where the gun ownership is higher, you will see the correlation between high gun ownership and high gun deaths.
I'm sorry, but you're wrong. Look at the FBI Uniform Crime Report. It says that gun crime is down all across the United States. If you break it down by places like Chicago, Washington, D.C., New York City, Detroit, etc., you'll find that those very strong gun laws that they have there have not led to reductions in gun crime. So let's not be